If Evan Rachel Wood's anti-slaps are successful, is she still being sued or is she removed entirely from the lawsuit? Welcome to the Manson cases. My name is Lisa and I cover the Marilyn Manson accusations, lawsuits, and legal filings. Today I'm joined by two attorneys who are also YouTubers that cover the Marilyn Manson lawsuits, Andrea Burkhart and Steve of Southern Law. Thank you for joining me today. To start, would you guys like to introduce yourself and your channel and where we can find you, starting with Andrea?
Yeah, so my name is Andrea Burkhart. I'm a practicing criminal defense attorney in the state of Washington. You can find me on Twitter and YouTube at A Burkhart Law.
And I'm Steve, and my channel is Southern Law, and that's because I'm in North Carolina, what's left of the South.
Love it. So how are you guys doing with this recent big news that Ashley Morgan Smithline's case has been dismissed? She was a big named accuser. She's been promoted in People magazine. You can see right here, she was on the cover of their magazine, making very serious allegations. She was highly promoted in the Phoenix Rising documentary. So this is a big person, even though she's not really, say, a famous celebrity like Evan Rachel Wood or Esme Bianco. But she really made her accusations known and promoted them.
Well, I'm not surprised. Obviously, the court had set it up for that, and it looked like that's all she was going to let it happen, was just let the clock run out and not bother with anything. I was a little surprised, I guess, that she didn't even bother to answer communications from Howard King at the address that was left for her with the court, but not very surprised. I don't know if Andrea has a different take on that.
No, I agree. I'm not only not surprised that the dismissal was granted, I'm also not surprised that she has just kind of ghosted the whole situation. From what we did see of her communications with Howard King and her own attorney, it did look pretty clearly like she was trying as much as she could to just get out of the entire situation. So under her circumstances, if that's what she wants, vanishing is really the best course of action for her.
When you consider some of these DMs, she's talking to people, a lot of people, even Eric Hunley, he was talking about that, I think recently on Popcorn Planet. I'm not sure if she's just trying to bail or if she just doesn't want to use that attorney. Like, the whole situation is bizarre considering the whole scenario with Jay Elwanger requesting to withdraw as her attorney. So what did you guys think about that situation when that happened?
Well, I started hearing about it before it came up, probably like a lot of people, because as I said the other day on Eric's stream, I'm one of the few people, probably maybe Andrea too, who's never gotten a DM from Ashley Smithline. So everything I get is third hand, and I'd like to keep it that way. I'm not asking for that. But I had heard, that they were dissatisfied. In fact, that she had fired him, but the court record had nothing in it. So I'm like, no, that's still who her lawyer is. Then I saw a little bit of the oven firing video, and that's bizarre. And I can understand the attorney's desire to get on the phone with her, because she has previously said, like, I've been hacked. People impersonate me very well. How do you even know she's the one doing the firing? But once you conclude that, you need to alert the court and withdraw, which is eventually, of course, what happened. But I haven't been in that many withdrawal things personally where I've wanted to fire the client or whatever. In fact, just one. But you ideally don't want that person communicating with the other counsel, talking about how you're worse than a fruit bat. So this thing just really went pretty wild pretty quickly. And then all the DM nonsense to pro-Manson people and to anti-Manson people, it was just, it was a lot to try and figure out what's really the truth here.
For those of you who want to learn more about the Ashley Morgan Smithline drama with her attorney, Jay Elwanger, you could actually go to Southern Law's YouTube channel and watch this video to learn more.
The thing that really caught my attention from it was just really highlights what can be a real pitfall in trying to represent multiple clients involving a single cause of action, because it really is a minefield in terms of creating potential conflicts of interest. It works just fine as long as your clients are both on the same page, they have the same strategy, their interests are in alignment. But as soon as that changes, that can create some pretty big problems for the attorney to be able to stay on in the case. So I have been watching and will continue to watch for the possibility that that could continue to cause problems for Mr. Elwanger to continue representing Esme Bianco, even though Ashley Smithline is, no longer his client and isn't pursuing a case anymore, these types of conflicts can potentially implicate your ability to represent both of those clients. So we don't know, of course, the details of what happened during the motion to withdraw hearing. It was conducted in chambers, so all of those conversations were had privately with the judge. But it is possible that if they're able to get Ashley Smithline deposed, get more information from her about, what exactly did go south with this representation, that could potentially cause some problems in the future.
Just to make sure people know that, he's representing both Bianco, or he was representing Smithline. He is representing Bianco, and Smithline was going to be deposed in Bianco's case. And that whole subpoena situation and her not showing up, that blew up. So he's got a blown up client over here that's supposed to be a witness in this other case where he's representing the person. So that is an epic disaster, and it may not be over. I agree.
How do you think this might affect, say, Esme Bianco's case, considering she was a third-party deposition and now they can't locate her according to these recent filings?
Yeah, well, like Steve pointed out, it's a potentially messy here because she has been identified as a witness, but now we don't necessarily know where she is, and that's applicable to both sides, kind of being able to locate her. Her sort of vanishing into the ether in the midst of all of this is not particularly helpful from a circumstantial standpoint for Esme Bianco's case. Might tend to put a little bit of weight on the side of the scale of, Marilyn Manson arguing that this was just a conspiracy that was for these alternative PR types of purposes, as profile raising stuff that making these Me Too accusations basically got them. So it doesn't help them really from a factual standpoint for her to vanish. That's sort of an open question how that could potentially play out down the road in a trial type of setting. That's such a long ways away that I don't really want to anticipate that at this point. But it does create a big question about whether they're going to be able to locate her to take her deposition. And that's something that I would think both of them want to have at this point. Although, frankly, by now, Marilyn Manson probably wants it more than Esme Bianco does.
Well, and here, just to point out, Andrea, a weirdo situation. If she shows up for a deposition, is she going to have a lawyer or not? Probably not. Probably she's not going to show up. Okay. If she were going to do that, she would have done it. But so what happens then? Elvinger's going to sit there and ask his former client questions about the actual fact pattern that he represented her on, and it exploded. It's a bad situation. And maybe he's hoping she stays in Thailand or wherever she may be at this point, and stays low. I don't know.
Yeah, no, 100%. I think that's a great point.
Because people have asked this. Her case was dismissed without prejudice. And the use of those words, prejudice, in a common sense, maybe makes people think something other than what it is. But the court is saying that potentially she could refile it. So is that likely to happen? And I don't think so. Who's going to do it? Is she going to do it? She's not going to do it herself. She's not going to pay a lawyer to do it, I wouldn't think. And if I were a contingency fee lawyer, I would look at her relationship with her prior attorney and it blowing up while Bianco's didn't blow up, and think, do I want to hold that grenade and see if it kills me or the enemy? I don't know. I would doubt we would see her case again, in my opinion.
Yeah, another problem too with if she were to go shop this to other contingency attorneys is that the first attorney with a contingency case is particularly bad to go through a series of different lawyers, because each one of them, since they're working on contingency, they're not getting paid until the case is over and there's something to collect on. That means they will typically end up with a lien on the settlement for, some proportion of it that's relative to what they contributed to it. So a new lawyer who's getting on board this case already knows, okay, if we have a, say, 30% contingency fee, we're going to have to discount that by whatever the original attorney is going to be able to claim for the work that he did. So you're getting paid less, for doing what is essentially the same job. And that makes it very not enticing.
In recent weeks, Esme Bianco filed the new third amended complaint. This relates to the one cause of action that was dropped in December.
So the court had granted, well, Manson asked for a few things. And one thing he asked was that the court not take jurisdiction over these Deftones claims, saying that they were not connected enough with the other claims for the court to have jurisdiction for that because they're state court claims. Just let the state court deal with it if she wants to sue. But the court said, which I think was the right call, nah, it's all kind of all the same stuff. But the court did agree that Bianco had failed to allege enough factual predicate for an element of one of her causes of action. And one of those was, hey, that he caused a breach of my contract with Deftones. The other is he interfered with my future economic activity with Deftones. And they said, well, you have to have shown, or you needed to plead in your complaint a specific unlawful or wrongful act that Manson had done, and you didn't do that. You just said he used his power and influence or whatever. So we're going to throw it out, but we're going to give you 20 days if you think you have those facts to replead your complaint. And that's what she did. She came up with her third complaint and made some subtle changes to it.
And here are some of those changes. I posted this on Instagram so people could see it. In her second amended complaint from last May, it looks like she just said, proceeded to contact the band, Marilyn Manson that is, to confront them over the Deftones' decision to work with Miss Bianco. And what's changed, it looks like, is they're a little bit more specific to call the band's lead singer and confront him. And that's very interesting. And then, let's see, I'll just actually go with the second one. Defendant Warner committed an independently wrongful act when he threatened the Deftones with actions that would disrupt the band's world tour and which would have caused the Deftones financial harm. Andrea, does that make sense to sue Marilyn Manson for this with this lawsuit?
Well, not under this cause of action, in my opinion. I don't think this is getting anywhere near the hurdle that they're going to have to clear to keep this claim alive. I see this claim as largely being duplicative of the similar cause of action for tortious interference with contract. I mean, this is all just dealing with, this deal that she allegedly had with the Deftones. And so if the other cause of action is allowed to go forward, which so far it has been, the court did say that, yes, there's sufficient facts pleaded to support that cause of action, then I don't know that she's really necessarily losing a whole lot if she can't also argue the same thing under these independent grounds. But the law for this particular cause of action, the tortious interference with prospective economic advantage, is very clear that the type of wrongful act that you have to establish needs to be more than just, it looks bad, like it needs to violate the law in some way. And this just, sort of ambiguous, what does this even mean? Threaten the Deftones with actions that would disrupt the band's world tour. I mean, there's nothing in there that necessarily makes that illegal. These things have very specific definitions, and so this, to my eye, is not coming close to meeting that standard.
Yeah, the court noted in its order that Bianco's attorneys had said, look, we don't really know what he said. We'll figure it out in discovery. So if suddenly they had figured out what he said, well, maybe a witness would tell them that. But I guess I give the attorney a little bit of credit because I don't think he did much in this amended complaint. He did file it, but it's not like he created a fantasy. He just basically said he called them on the phone and threatened to disrupt them. So calling somebody is not an unlawful act. And disrupting, to me, is not inherently unlawful or violating a standard, because there are lots of ways to people disrupt things all the time that they don't like, and it's not all a cause of action. So I think they needed to show that he threatened to kill them, or he threatened to, to do something, some kind of violation of a statute or whatever. And they didn't say any of those things. So to me, they didn't move the ball forward like they needed to. But, who knows how long it takes to get another motion to dismiss queued up and decided, especially with this motion to stay on the docket.
Oh, really? So it needs to be something a little bit more severe than, say, making a phone call, making a threat like that.
Yeah,
it has to be something illegal. It has to be something illegal. And the problem is that threats fall under the First Amendment, like all speech does. And so they also have a very specific technical legal definition. And like Steve has indicated, it's a threat of death or serious bodily harm that is places another person in reasonable fear that the threat is going to be carried out. So they would have to show something like that if they want to say, well, he committed an illegal threat, and that's the independent wrongful act. But they don't allege that, so it's not going to satisfy that standard.
Because he could disrupt them by saying, I'm going to show up at venues and say, these guys are lame. They've lost their mojo. Don't listen to them. I'll give a free concert at the same night at the same city. And those things aren't. So yeah, I don't think that they showed the facts that the court asked them to do.
The judge kept the one cause of action, then dismissed the second part of that in leave to amend. So I'm assuming this is why we're seeing that third amended complaint. Are we going to see a motion for that, or it's just amended and we're going to kind of see something move forward from here? Well, depending on how the stay, how that plays out now, since we're going to talk about that. It looks like Howard King, Marilyn Manson's attorney, wants to have a stay in the case based on a provision in the human trafficking statute, or the act, I should say. And I found that very interesting. And I get a lot of questions like, why didn't they do this sooner?
Well, when I looked it up, some of the case law on it, there were times when defendants tried to invoke this stay provision, and the court said, no, you're not showing us enough evidence that you're actually under investigation. So we're not going to let you invoke this stay. So if you come to the court too early and without enough evidence that you're actually under investigation or this potential criminal prosecution, then you can't get the stay. So if you're Manson's side, you say, look, we did the right thing here. We waited until we felt really confident about it. There's not an estoppel situation here, because in fact, the case law says don't come too early. Don't come until you really have a good handle on this. So I think, while I understand Ellwanger saying, hey man, we've been in this case for a long time, this sucks to have this case stayed, I like cases to go forward, so that resonates, but that's not what the statute says, in my opinion. The statute says that it should be stayed if it's under investigation or under prosecution or potential prosecution, the way I read it.
Yeah, I think that makes perfect sense. I wouldn't rule out that there may be strategic reasons for the timing, just given how discovery often tends to unfold in civil cases. You tend to get your written discovery and your document discovery before you go forward with your depositions. And so it's possible that they've reached a point where they've received a lot of information through the document and interrogatory type of discovery, but maybe it would be good to wait before Marilyn Manson sits down for his deposition, so this could be an advantage to them in that particular respect. But of course, without being able to see behind the scenes, we really don't know that. It's just a possibility I would not rule out.
And it looks like in the court filings that they still don't have Bianco's deposition, or what looks like a 35. Is that a medical, is my understanding? I think it's called a 35. And it seems like kind of a shitty spot to stop at, but also it's hard to know what's going on behind the scenes, especially as it relates to Marilyn Manson's lawsuit against Evan Rachel Wood and Ashley Ilmagore, because in the recent anti-SLAPP filings, we did see Bianco's name come up in some of the unredacted portions. So somehow Bianco is linked, but there's not enough information to know how or why, or how much more they have for this conspiracy, except for the fact that apparently the broken iPad has been imaged. So how much do they have and how little they've been putting out, but more so than Evan Rachel Wood and Ashley Ilmagore, that we know they have something there, but what more do they have?
Certainly, I've seen plenty of Twitter comments about it, which is, hey, if Manson's worried about his career is stopped while this is going on, and he's got all this stuff to clear his name, why would he want this case to be stayed? And, those are fair points from a narrative standpoint. So I guess, when the anti-SLAPP motions were filed, and that's what we'll talk about in a moment, Wood and Gore were trying to resist discovery. They didn't want to give depositions. Well, if they're accusers, why don't they tell their story? Well, their lawyers don't want them sitting down for, and in fact, I don't think Gore came off as good in her deposition as I thought she might for purposes of state of mind, because I thought her attorney's brief was great. But having said that, the point is Manson's under attorney advice for this stay. He's not like he's sitting around thinking this stuff up. That's what they're getting paid to do. So I think it's fair to say for both sides, the timing of when they talk in depositions and how they maneuver the litigation is is up to the lawyer, and it's not really, I think, fair to destroy either side's narrative based on what the maneuvers the lawyers make.
Well, and part of the reason I imagine that this stay provision exists in the first place, there's probably a lot of reasons, but one of them may be because of the fact that when you have these overlapping civil and potential criminal issues, you are going to run into the likelihood that your, civil defendant is going to plead the fifth, that they are in a situation where they cannot afford to be full and fair and open in their deposition because they might get criminally charged as a result of what they say. So it's almost certain that, from my standpoint, if Marilyn Manson were to sit down for his deposition without knowing if this investigation is concluded or not, he's putting himself at pretty serious jeopardy to answer these types of questions. So from that standpoint, it makes a lot of sense to me why Marilyn Manson wants to be sure that that is closed. Not that it can't be reopened, but it just makes it a lot harder to give them new information that would justify reopening the case, as opposed to if they're already, inclined to go down the road of prosecution, and then they can just pick things out from your deposition, that may tend to support what they're trying to establish. It just puts him in a very difficult situation to be able to do that.
I realized it was like 190 of them. Is that normal?
Yes and no. I mean, yes, in the sense that if there is something objectionable, you need to object to it. If you don't object to it, you waive your objection. And so that can be, a bit of an own goal if you miss something that you should have caught. At the same time, most people do tend to, exercise some judgment over what is the strongest thing here and let go maybe things that don't matter as much. To raise 190 is being pretty thorough, which may be a little bit more unusual to have such a broad net of objections. Well, they don't want his evidence to be considered. They want to limit as much as possible how much the judge will pay attention to what he has submitted in response to their anti-SLAPP motion. So more that they can pare that down, the better chance they have of getting the motion granted.
Yeah, especially when you look at just Ilma Gore's deposition, and correct me if I'm wrong, it was limited to groupie, but was that because of the infliction? I'm sorry if I'm.
It was for her state of mind, I think, when she made the statements about the groupie video.
Is that common? I've never heard of that before when it comes to comments like that, but this is a very unusual lawsuit.
Well, it's because of the posture of this, since it was a request for her deposition in light of the fact that the anti-SLAPP motion had been filed, and so the discovery stay was in place. And so it wasn't just a normal course of events, we're going to go ask for somebody's deposition and do whatever, because they had to go to court and ask for permission for it anyway, and to establish for the court, this is why it's relevant to the anti-SLAPP. This isn't a deposition that's just broadly dealing with the issues of the case. It's very targeted to the issues of the anti-SLAPP. And so that's why it focused just on that issue with the mental state concerning the groupie, because they need to know that if they're going to have, a meaningful argument about this defamation claim and whether it's barred or not.
Right, and they didn't even let Ilma Gore answer if, when she was Evan Rachel Wood's girlfriend, which I think maybe it's just me and maybe I'm biased, but I think that would be relevant, especially if you're asking about groupie, because a lot of people don't know what groupie is generally, unless you've been connected to Marilyn Manson or at least a fan to know you've heard of groupie in the fandom. Was there anything in here, Steve, that you thought was pretty damning or you had more questions on?
Well, in terms of her state of mind argument and Manson's argument about it, I figured really from the beginning, the judge is going to let this move forward, right? Just on the face of it, the allegation of the type of allegations she made about him and the allegations he had already said, that we're going to destroy him, and the allegations about the conspiracy and stuff, that was enough there to show some malice. But anyway, I thought her attorneys briefed that up and educated me on the law on it as to why the judge might have some concerns about that in terms of it being a subjective test. And then it devolves down into this: should she have investigated more? What was the basis for what she thought? Why was she doing it? Did she basically harbor real doubts about the truth of what she was saying? And I thought her attorneys did a good job on the brief. I found her, the deposition excerpts, in my opinion, were a little more mixed on that. Like, I thought her story would be more coherent on how she found out about it and why she believed the particular things that she said about it, because that to me remained a little ambiguous in that. The main thing I was surprised at in the excerpts was how many people, as I read it, she claimed told her they had seen this horrifying video. I thought no one had seen it other than Manson, and like the producer or whatever said never show this to anybody. But what I read in the deposition seemed to indicate that Wood had seen it and other people had seen it. So that was surprising to me.
Yeah, I agree with that. I don't think that Ilma Gore necessarily helped herself out a lot in this deposition. I had some questions anyway about how helpful it was really going to be likely to end up being. Like Steve points out, the actual malice, it is going to be a subjective standard. It's proving she actually legitimately entertained doubts of what she was saying. And so that's always one of those things that's difficult to prove because, of course, you can't see directly into somebody's mind. It's always circumstantial. And certainly what she has to say about it is one piece of circumstantial evidence of what's in her mind, but it's not binding. You know, we don't have to accept that something is true simply because Ilma Gore said it. And it's not even necessarily the best evidence. You know, I'm a criminal defense lawyer. I'm regularly dealing with situations where, you know, what people say doesn't tend to line up with the rest of the evidence that is out there in the world. So I didn't really have high hopes that this was going to be a super fruitful undertaking for them. And given that, I personally think it actually went better than maybe I would have expected it to.
Now, what I found interesting is, at least when it comes to the deposition, and I'm going to pull that up real quick, is learning that not only was Marilyn Manson there to listen onto this deposition, was that there was audio. And it appears at least one of them mentions it's that Michelle Myers, whose phone number was on the fake FBI letter. And now that I have a lot more questions on who recorded that. Is it on the iPad? Is it something that she recorded? Because apparently she's an attorney. What kind of questions did you guys have with the deposition? And I'll start with Steve.
It sounded to me like she was recording it, that the Myers was recording it. I thought that's where they got this, that Manson's side got this information from. But I could be wrong. Like you said, it could be the iPad.
It was not clear to me exactly what that provenance was.
What did you guys think of Ilma Gore's? It looks like changing stories about how she learned about Group E. First, it was something to the effect of she found it online, but then somehow she mentioned Evan Rachel Wood later on. Did you catch that, Andrea?
Yeah, I did. I noticed that there is not a whole lot of consistency in the story here, like Steve said at the outset. I also would have expected, you know, something a little bit more coherent and consistent. But that was certainly a problem. The explanation she gave of, you know, supposedly being just randomly contacted out of the blue by somebody who is supposedly, you know, the subject of this video, and, you know, just this rather implausible explanation from my standpoint, because you would have to, I think, have at least some explanation for why you would credit this, why you would authenticate this as legitimate. You know, how do you know this person is who they say they are, and so forth? Most of us wouldn't just go around throwing out random child abuse accusations against somebody because some unknown person said something to us over, you know, a DM on an anonymous account. So even what she did provide when it was consistent is clearly intended to be exculpatory. She is trying to offer these explanations for what happened. But the problem is that she has also now opened up the door for discovery into all of that. Okay, you say you got a DM, Ilma. Well, now it's put up or shut up time. We want to see it. Prove it.
Really? That's interesting. Steve, was there anything in here you found interesting outside of Groupie or even with Groupie itself?
Not the movie, maybe, because I don't, really have any idea what it is or whatever. Just what surprised me out of it was the lack of direct narrative from point A to point B when you know your client's only going to be deposed on one thing. I just thought that would be more straightforward. But the main thing to me was, unless I missed or read it wrong, was that so many people had seen it when allegedly it was only, a couple of people or whatever. And so if so many people have seen it, I would have thought in her deposition, she would have said, I was told by X person that this underage thing occurred or whatever, in addition to the anonymous call. And I didn't see that in there. I wondered it sometimes, were there people trying to get her more riled up about this? Because she didn't see the video, right? Ilma Gore didn't see the video. So who's this call, if there was a call? And what kind of energy was there to get her worked up about this? Or is she self-worked up? I don't know the answer to that, because some of her past allegations, of things that she's experienced, I don't buy. So I'm not ready to swallow everything she says.
Yeah, and with Groupie, or even with the other lawsuits, I'll say, Jane Doe claims Groupie was only seen by 3 people. And what's interesting is if you look into this, saying Google, the whole spiel is Manson's ever showed 3 people was already a thing, 20 years ago, was something he said. And on top of it, you have in Esme Bianco's lawsuit, I believe Ashley Walters, both talk about a film that was basically traumatizing to them. And it seems or appears like it could be Groupie. Smithline says something about a film, but she literally says CP, that she was forced to watch CP.
Well, I do just think it's important to reiterate that with the anti-slaps, these are just partial. These are basically challenging one of the bases for, or some of the bases for the intentional infliction of emotional distress claim, but not all of them, and the defamation claim. And so there are multiple causes of action that are going to survive and move forward and go into discovery and potentially trial, regardless of what the ruling is on this anti-slap. So I just think that's important to bear in mind, because a lot of times in these situations, you are looking at a situation where it's all or nothing. You win it or you're done, but that is not going to be the case here.
Now, as it pertains to the FBI letter, since the FBI letter is a hot topic and that's being challenged and could possibly go away, what are your positions right now as it relates to the FBI letter? If it's tossed out, is it also discoverable? And I'll start with Steve, if that's all right.
Well, I think if it gets struck, and once I don't know if the case is going to get stayed after that or not, depending on appeals, but let's say magically in the future something's happening. Discoverable, they've already discovered it. Now, can they ask more questions about it? In my opinion, they should be able to do that. I think I'm trying to remember how we framed this before, because the idea is it gone from the lawsuit in any material way? In my opinion, would have been if it gets struck, it would be, because if I were the judge, I'd be like, look, we already had this as a slap thing, so it's out of this case, and I'm not going to let you backdoor it back in here for some other purpose. If you had another purpose, you should have put that in the lawsuit to begin with. I'm not going to let you backdoor this in. Having said that, that's just an opinion, because Andrea had cited her understanding of the discovery rules, which I completely agree with. And to me, obviously, the reason Manson wants this thing in there is it is material to credibility. It's way material. It's really big, and that's why they want it struck so much. So the judge could, of course, let it in for all different other kinds of purposes other than the basis for that cause of action for which it might be struck. So I wouldn't bet money on it on my own position. It's just the opinion that I came when I was thinking of this judge like this.
And I think Steve had actually made a very good point that I really hadn't considered, frankly, which is that given the purpose of the anti-slap statute is to protect people from oppressive litigation, including the discovery process, that it doesn't necessarily make a lot of sense to say, okay, you can't file a claim based on, this fraudulent FBI letter, but we're still going to let you go ahead and do all of the discovery and the things that are, potentially harassing with it anyway, doesn't necessarily add up. And I do think that is a very good point. Were this less central to not just her credibility in general, but her credibility when it comes to these specific allegations and the circumstances in which they were brought forward, potentially shared with other people, and just kind of the picture of the overall motive for what was going on here, then I think that would very much, I would be concerned about that if I were Marilyn Manson. But because I see it as being pretty central to what's going on in this case in terms of sorting out who do we believe or who do we don't, then my guess is that the general presumption that discovery is broad. It's much broader than just what you get to use at trial. You get to investigate your case and look for evidence. I think that presumption is probably going to apply here. They'll still be able to review it. Whether or not it gets admitted at trial, of course, we'll find out way down the road.
And saying all of that, if Evan Rachel Wood's anti-slaps are successful, is she still being sued or is she removed entirely from the lawsuit?
Yeah, she is still being sued. She's still being sued for at least one basis for intentional infliction of emotional distress. She's still being sued for the cyber harassment, whatever that claim was, the computer crimes allegation. So yeah, she is still being sued. She is still a defendant.
Do you agree with that, Steve?
Yes. Now, if I'm her team and the judge says, I don't buy the conspiracy for the groupie comments, and this case doesn't stay or whatever, I might be trying to tee up some motions to dismiss on his, if to the degree I'm in on a conspiracy basis, because I got a judge who doesn't believe in conspiracies. Because I thought Manson did allege that I would have ruled the other way than she did in her discovery ruling. But absolutely, even if they win this slap motion, she's still in on these other things. They're not even subject to question at this point, I don't think.